Okay, hello and welcome. My name is Monica Crooms Mkhikian. I am an immigration attorney with the U.S. Immigration Law Group in Santa Ana, California. We are a full scope immigration law firm serving clients who have immigration needs that range from representation in immigration court to family-based petitions, applying for naturalization and renewing green cards, and also work-based petitions. So I'm honored to be here today to host this teach-in topic, which is social media and immigration. So we will get started in just a minute. Okay, so social media presents a number of really important benefits to its users. We know that social media is a way for us to achieve and sustain effective communication with friends, family, colleagues, and people who we may not necessarily be as regularly connected to in our lives with sort of life and responsibilities, but social media sort of provides us with opportunities to have easy means of communication with people. It's a way to stay connected with people. Social media is also a way for us to network and gain access to various sources of information and share milestones with friends and family. So there are a number of benefits and perks to having social media accounts and being connected to members of society through social media. And also it's not just, members of society who are in close proximity to us, but through social media, we're able to connect with people across the world and around the world. And the immigration agencies in the United States know this. Social media, given the importance that we tend to attribute to it to represent ourselves, right? We use social media as a way to present ourselves to the world. And so the federal agencies responsible for processing immigration applications are keenly aware of the vast types of information that they may be able to access through an applicant's social media. Therefore, as of 2019, so immigration actually began surveying applicants' social media platforms before 2019, but in 2019, formally, immigration policies required that the U.S. Department of Homeland Security and the U.S. Department of State actually, or rather not required, but allowed these agencies to require applicants to provide sensitive information pertaining to their social media accounts, so that USCIS, agencies like USCIS, the National Visa Center, ICE, and the Customs and Border Patrol could access those accounts. In addition, other information that the officers of these agencies can request are the email addresses that access the accounts, as well as phone numbers, passwords, handles, usernames. So foreign nationals applying for US visas from outside of the United States and individuals who are inside the United States requesting immigration benefits are cautioned to scrub their social media. They're cautioned to review their social media. I personally have had social media accounts for, over 13 years. I do not remember half of the content that I myself have posted on my social media because it's been so long. And so specifically to applicants who are seeking immigrant visas at the U.S. consulates outside of the United States, in the form DS-260, individuals are actually required to provide their social media and contact history for the previous 5 years prior to submitting their applications. According to the Department of State, this additional information will strengthen the government's efforts to vet applicants and confirm identity. But we'll talk a little bit about how perhaps those efforts or the goals that strengthening those efforts may violate someone's rights to privacy, but because they're abroad and applying for U.S. Immigration benefits, those protections are not in place and are not able to prevent the government from accessing their social media. Okay. So as I said, various federal agencies, including the Department of Homeland Security, as well as the Department of State these are the primary agencies with respect to immigration processes who have access to or who may request access to applicants' social media. Again, they are entitled to ask under these 2019 regulations, are able to ask for applicants' usernames, identifiers, handles, and they're able to not only access them, but then also passively monitor them. The government is now known to be creating sort of bogus profiles so that they can observe applicants' social media sort of movement or social media presence in that way as well. So as opposed to just directly accessing their accounts by requesting their usernames and passwords, they can actually, they are actually creating government, bogus government accounts to also monitor the applicant's presence on social media. And so the US-based social media platforms that the government is accessing and monitoring include Facebook, Pinterest, Reddit, Tumblr, Twitter, Vine, YouTube, LinkedIn, Instagram, MySpace, Pinterest, I think I might have said, Google+, and Flickr. There are also Chinese sites that are being monitored, which include Douban, Qzone, Sina Weibo, Tencent Weibo, and Youku, and the Russian social network VKontakte. So these are some examples, but I mean, essentially, our recommendation is if you have social media accounts in any country that are based in any country, expect and anticipate that if you are applying for a immigration benefit, to immigrate to the United States or to enter the United States as a non-immigrant, you should expect that immigration may potentially try to access your social media account. So what's the point? In what ways can the government, the US government, use social media information to make immigration or determinations for immigration benefits? So some of the ways include, for example, applications, non-immigrant and immigrant visas at the US consulate, are subject to requesting that information because the officers will presumably use the social media content to determine whether or not the applicant has questionable affiliations, or to see if they are a perceived national security threat based on the content of their social media profiles. So one example that I read about that was quite disturbing actually, but let me just access those notes. One example of how the government can make a determination about whether a person presents a national security threat through social media may not even require the applicant themselves to post questionable content. If in fact a friend or a contact on such media platforms has themselves made posts that may be deemed a threat, a national security risk or a national threat to the United States, and not necessarily in that they posted it on the applicant's social media page, but just by virtue of being connected to the applicant and having posted such content on their own page, then the applicant actually may be affected. So in the example that I'm going to present, there was an applicant for a student visa who had been accepted to an Ivy League school. They were a student from Lebanon, and they were actually refused entry at the border. So their application for the visa was not denied, but once they arrived to the US port of entry at the airport, they were not permitted to enter the US under their student visa. And it is because they were referred to secondary inspection, and upon being referred to secondary inspection, the CBP or Customs and Border Patrol agent took the phone away and looked through the applicant or the student's phone, and in the social media account there was a connection to someone who had posted something that was deemed a threat to the US interests. And so when the student was asked by the ICE officer to confirm whether or not they liked the content, they had actually acknowledged it, they had shared it, had commented on it. The student, you know, they had not. So the student, you know, confidently said no, but they were nonetheless not permitted to enter the United States based on that content that someone else had posted on their own page. And so social media is being used in ways that can be very prejudicial and to the applicant. I mean, I mean, in that context, the applicant or the student, they had no control over what their affiliate was posting on their own personal webpage. But yet they were being penalized and they were being refused admission. Now, ultimately, that person was able to enter the United States after, you know, great and significant effort, but they went through, I'm sure, a very stressful period of time, you know, not knowing whether or not they would be admitted based on something that was completely out of their control. Okay, back to the other ways in which immigration that most commonly uses social media content to screen applicants for admission to the US or for benefits. Now, that example perhaps was more of an extreme example of how social media can be used to exclude someone at the border. How common that is, I'm not able to say at this time, but I mean, let it just be an example as to the ways that the US government can use social media content against an applicant. And so it should inform individuals who are seeking to gain admission or who are seeking to apply for benefits to, you know, be aware of what others are posting on their own social media and maybe considering whether or not they should keep that connection in the event that it could prejudice them, it could affect them entering the United States. Okay, so let's see. Okay, the other most common way that the U.S. government will use content on social media accounts is to determine whether or not applicants for a marriage-based petition are actually in what's called a bona fide marriage or in a marriage that is valid for immigration purposes. And so if there is information on either of the applicant's social media accounts that is not consistent with the benefit that they're seeking, which is a marriage-based petition, then they could be denied, their petition could be denied. And so one example that I personally experienced in this context was I had a client, I had two clients who were a married couple, and they both had social media and they just hadn't been monitoring or using their social media frequently at the time that they got married. And so when they went to the interview, the officer, sort of point blank asked one of them, why on your social media does your profile or does your marital status show as single? And it was because the applicant, my client, had no idea. They didn't remember that their marital status had single, and because they didn't use the platform often at all, it just never occurred to them to change it. And so fortunately, despite the marital status saying single, there were few, I mean, not very many, but there were posts that that were consistent with him being married to his wife. And so they were able to overcome that sort of challenge by the immigration officer, but it was definitely something that made them sweat during their interview, that made me sweat during their interview. And then, as I said, the Customs and Border Patrol has discretion at the border when referring or when anyone is seeking admission at the U.S. border. And if they're referred to secondary inspection, the Border Patrol is able to access their luggage and also access any electronics, including phones, computers, and tablets. And so if there's any, content or information in any of the individual's devices that would suggest that they are a national security threat, or that they're actually misrepresenting themselves to immigration based on whatever applications they have previously submitted, then they could be, they could be facing severe prejudice and severe inconvenience, because they could be refused admission. And if someone is refused admission at the border, it becomes very difficult in the future to be able to gain admission to come back to the United States or to enter the United States. It's not impossible, but it's definitely something to avoid, and it's definitely something to be conscious of when traveling, and when traveling with devices that contain so much personal information about us. Okay, and then also with respect, I've been speaking a lot about marriage-based petitions and non-immigrant visas, student visas, but also with respect to employment-based petitions, the federal agencies that adjudicate those applications will also access accounts on LinkedIn. They'll check the employer's website if it's an employer-based petition, to see if the content on those websites is consistent with the person's application. So sometimes employers will post an employee profile on their website before the work authorization document is approved. And so that would suggest that potentially the applicant is working without authorization, and then may trigger unlawful presence in the United States. Sometimes an employee or an applicant will add an employment history on their social media, like on LinkedIn, when they were not authorized to work. And so then that is how USCIS can verify whether or not the applicant was working without authorization. So, a common question, and not just a question, something that many people have employed when confronting this question and confronting a request for information to access their social media, is they just don't disclose it. They just, they check none, and they do not provide the information. Now, this can also be very problematic. A failure to volunteer information to the U.S. government may not automatically or necessarily be construed as misrepresentation, but the current version of the immigration forms do not provide an opportunity for the applicant to refuse to give an answer. So by not providing the information, or by omitting the information, then they're not providing a truthful answer. And so his or her response could actually be construed as a lie or a misrepresentation to immigration, because they're requesting the social media access to the social media platforms that one has had and used for the last 5 years. And so if you have a Facebook account and it's not deleted, and you do not disclose that on your application, your DS-260 application, when you're applying for an immigrant visa at the consulate, and the Department of State officer is able to find that profile using their own, bogus profiles, then you may stand to have to explain yourself at an interview as to why you indicated that you did not have that platform, or you may not even have that opportunity. They might simply deny or revoke a petition because they made a finding that the applicant made a misrepresentation to the Department of State by not answering the question or not providing the information requested. Okay. So let's see. So what are best practices for navigating the U.S. federal government's increasing use of social media? So I think that in many cases, visa applicants would be wise to maybe reduce their social media presence, or scrub their accounts, basically go through the entire account, which might take a while, but go through the entire account and make sure that there's no information that's in that account that would be prejudicial to them as applicants for an immigration benefit. It might be wise to just cancel the profile, or to delete the profile until you've completed the process, the immigration process. I mean, you could still disclose, even you should still be forthcoming and truthful about the social media platforms that you've been using over the last 5 years or whatever span of time they ask for, but delete the account. And so if they access the account, if they try to access the account, it'll be deleted, and maybe even still scrub it, even if you're going to delete it, because if you can access the account just by signing in, or if you can revive the account merely by signing in, then they may still have access to information that you have not had an opportunity to monitor. But I think probably the most prudent thing to do would be to review the content, no matter what, of the profiles, and then maybe just even delete them until you are in the clear, until you've been issued your document, your immigration benefit. Visa applicants should ensure that their LinkedIn profile, Indeed profile, or whatever profile that's used as a host for employment resumes or employment opportunities or seeking employment opportunities, make sure that the timeframes that are published on those websites do not conflict with any period of time that you may not have been authorized to work in the United States. And make sure that you are, requesting, or that you're talking to your employers about not prematurely posting information, including announcements or press releases or profiles about you as a prospective employee until you've received your employment authorization. That, you just don't want there to be, I mean, I'm sure that in the event that there was an announcement, you could negate that you've actually been working, I'm sure, but it just presents unnecessary stress and hassle and difficulty for you. And then, immigration then sort of presumes that you're lying. And so you just don't want to, you don't want immigration to be making those kinds of assumptions, because it will make the application process and the adjudication process just that much more difficult. And then also, just being mindful about who you are associating with on social media. Be mindful about, anyone that you're connected to that tends to be very vocal about controversial issues, or issues that may be deemed controversial by a immigration officer, or might be deemed a threat to national security. Because as I described in the example of the student arriving to attend an Ivy League university, they were essentially being, punished. They were, they were being refused entry into the United States because of views that someone they were connected to held, and views that they actually were not affiliating with. They did not comment on. They did not, they did not like. They did not even acknowledge, but yet that the views of those individual, or that individual who they were connected to, was being used to potentially prevent them from entering the United States and being able to attend the university. And so, in this very digital and virtual age that we find ourselves in, and again, despite all of the benefits that are presented, by social media, or having social media, and the conveniences of having social media, these platforms are platforms on which we tend to share a great amount of information, sometimes without a second thought. And this information, actually has and may potentially have, or posting this information may have very real consequences for one's future in the United States if they're seeking to apply for an immigration benefit. So again, I highly, highly encourage you that to review your social media platforms, review your accounts, scrub them, make sure that there is nothing, on there from your youth that you may regret at this time in your life, and that an immigration officer may use against you in adjudicating an application. It's important that in any context when applying for an immigration benefit, it's incredibly important that the applicant be truthful and that they present information accurately to avoid a finding of misrepresentation. But it's also important that they understand, what the consequences of the information they've shared can be. And so, as always, I recommend that if you are seeking an immigration benefit, that you definitely consult with an immigration attorney, with an immigration attorney, and just make sure that you're aware of what the implications are of your social media, so that you don't find yourself unintentionally in a situation that is very stressful, stress-inducing. Our office is here for you, is here to assess any kind of social media issues. You're more than welcome to visit our website at usilg.net. And you're welcome to also schedule a consultation or an appointment to speak with an attorney via our website. Our goal is to make sure that people have access to information that will assist them through the process of applying for immigration benefits. And so with that, I thank you for your time. I thank you for allowing me this opportunity to share this information with you. And I encourage you to contact us, and if not to contact us, but to visit our website again and our social media platforms, which are Facebook, Instagram, and Twitter, where we do our best to share relevant and important updates about immigration law. There's a lot happening these days where, at the start of a new administration, the Biden administration, and there are discussions about many possible policy changes in the future. And so please think of us as a resource. We are U.S. Immigration Law Group in Santa Ana, California, and we thank you for your time today.